developments in Tanzania with the Maasai community, we converge here at the Kenya Human Rights Commission today to guarantee them our support and express our concerns with the judgment by the East African Court of Justice in reference to petition number 10 of 2017, Ololoskwan Village Council and 3 others versus the Attorney General of Tanzania. So on 30th September 2022, the East African Court of Justice dismissed a case, reference number 10 of 2017, brought against the Tanzanian government by 4 Maasai villages who sought recourse for violent evictions and the burning of homes in Loliondo by the government in 2017. The case, which has continued to make headlines, was brought forward after violent government-led evictions in the Maasai villages, which border the Serengeti National Park to the west. Of concern, the evictions of the Maasai from their lands have been encouraged by international conservation organizations, which have always portrayed indigenous communities as a threat to conservation. In its judgment, the court determined that the witnesses failed to prove that the evictions took place outside Serengeti National Park borders and that the testimonies about the violent evictions relied on hearsay. On the 2 bases, the court determined that there was insufficient evidence from the applicants to demonstrate that they were evicted from their village land and not from Serengeti National Park. The court totally paid a blind eye to the illegal arrests, shootings, and displacement suffered by the applicants, including women and children, but instead glossed over the compelling multitude of oral and affidavit evidence tendered by the villagers and the incontrovertible evidence of the expert witness, a respected and accomplished geospatial expert, on the mere basis that he was a Kenyan and had not sought a work permit to undertake surveys in Tanzania, which is not the true position. In fact, the community was forced to hire another expert after the previous Tanzanian expert, whom they had contracted, eventually dropped off following continuous intimidation from the state machinery. Thank you.
My name is Mary Campbell. I work here at the Kenya Human Rights Commission, as I had earlier introduced, and I'll pick from where Furaha has stopped. So the community was evicted from their land in 2017, after which a heavy military presence was deployed in the area to prevent accessibility. Apart from the testimonies from these community members, how else did the court expect the community to demonstrate they were evicted from their own village lands? What other proof of ownership did the court expect or require beyond the erected beacons? Noteworthy, the Universal Declaration on the Rights of Indigenous Peoples declares that indigenous peoples have the right to the full enjoyment of all human rights and fundamental freedoms as recognized in the UDHR, the Universal Declaration on Human Rights, and other international human rights laws. The declaration goes on to guarantee the rights of indigenous peoples to enjoy and to practice their cultures and customs, their religions. In addition, the UN framework and guiding principles on business and human rights provide that a global standard for corporates and state has to be maintained to prevent, address, and remedy human rights abuses. When national mechanisms fail, it is expected that independent regional and international mechanisms shall actually guarantee accountability and justice for everyone by holding state accountable for violations. However, this decision by the East African Court of Justice sets a dangerous precedent by sanitizing state impunity, and it also sends a message that governments can trample on human rights without being held accountable. The court's failure to hold the Tanzania government accountable for gross human rights violations not only throws its integrity into question, but it is also a travesty for all indigenous communities, especially to the more than 30,000 families who have lost their loved ones, property, including their land, homes, and livestock. And they are still reeling from physical and psychological wounds inflicted on them by the very government that is supposed to protect them. Its decision, and even in its conduct of postponing the judgment on the matter severally, raises serious eyebrows on the integrity of the court. Since its withdrawal from the African Court on Human and People's Rights in 2019, a human rights crisis has been building in Tanzania, consequently threatening the country's stability and democracy. Reports by Amnesty International indicate that Tanzania has had the highest number of cases filed against the country and judgments that have been ruled against it by the African Court. By September 2019, 28 decisions out of 70 decisions issued by the court were on Tanzania. In fact, the government of Tanzania was in contempt of court when it further conducted violent evictions in June this year, despite the court ordering it to stop all activities pending judgment on this matter. Recently, in September 2022, this year, the European Parliament expressed its grave concerns about human rights violations in Uganda and Tanzania linked to investments in fossil fuel projects, including the wrongful imprisonment of human rights defenders, and also the eviction of hundreds of people from their land without fair and adequate compensation.
Thank you, Mary.
As mentioned earlier, my name is Samantha Ann from PIDO, Manyoito Pastoralist Integrated Development Organization, the Executive Director at an acting capacity. I'm here to read this statement in solidarity with my people, the Ma of Loliondo in Tanzania. And I read. Reports by Auckland Institute highlight that the Ministry of Tourism and Natural Resources has indicated the area occupied by the Maasai has been identified as potential game reserve, which will certainly excavate evictions of the already affected community. The Suluhu administration needs to understand that when a government recklessly violates the rights of its citizens, international scrutiny and action is paramount. This growing hostility toward human rights, coupled with cynical attempts to evade accountability, will not be tolerated. Blatant abuse of human rights cannot be justified in the name of conservation. 2&2 benefit safari companies such as Boston-based Thompson Safaris and the UAE-based Otalo Business Company, which runs hunting excursions for the Emirati royal family. This is an outright contravention of the text and spirit of local legislation, including Tanzanian Land Act, Village Land Act, Wildlife Conservation Act, as well as regional and international human rights instruments, including the East African Community Treaty, African Charter on Human and People's Rights, Universal Declaration on Human Rights, International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, and Convention on the Elimination of All Forms of Racial Discrimination, which are premised on the respect for fundamental human rights and freedoms. We therefore hereby, 1, demand for immediate and unconditional release of the 24 Maasai elders who were arbitrarily arrested in June 2022 and remain illegally detained to date for taking a bold stand to oppose the illegal government evictions. 2, call upon the international community, including local, regional, and international civil society, to join us to exhaust every possible avenue to hold the Tanzanian government accountable. 3, call upon the international community to exert maximum pressure on the relevant companies as well as Tanzanian authorities, including imposing economic sanctions to guarantee respect and protection of indigenous land rights. 4, we demand that the government of Tanzania cease and desist from any further violations and undertakes to commit to using the best available means to provide reparations to preserve the dignity, culture, and the future of the communities affected and explore other alternatives in line with its international and regional treaty obligations. 5, we condemn exclusionary and militarized conservation approaches that restrict access to critical resources without providing for equal or better alternatives that undermine enjoyment of fundamental human rights and freedoms. We demand that indigenous communities must be at the center of global conservation effort. Thank you.
Thank you, comrades, for the statement. I would invite Martin to briefly tell us about the cases. This is just one of the cases. I think there are other 2 cases which are pending. And then what are we going to do about even this outrageous decision? And then from there, my other comrade will also give us some briefs and updates about what is really happening.
Thank you, Davis. Good morning, colleagues of the media. I am Martin Mavenjina. I work at the Kenya Human Rights Commission, and I'll just give you a brief about the cases that were filed by this community before the East African Court of Justice. So the case that we're dealing with, actually the matter that we're dealing, first and foremost, there are 3 cases that were filed by the Ma community. The first was filed by the Ma community that were living in Saleh. The other case was filed by the Ma community who are in Loliondo, and then the third, there is another third case. But a summation of 3 cases that all these cases emanate from the violations that have been attributed to the government of Tanzania. The first case was filed in 2016. A court order was issued early this year preventing the government of Tanzania from actually evicting the Maasai community. And when citizens of goodwill in Tanzania protested, the government, forgot about that threat. But fast forward about mid this year, they made good.